Yeah, hello students. This is the topic on judicial delivery system in India, which can be continued to see the latest in the consumer justice delivery system. You all know the principle of caveat emptor. That is, when we say the consumer, though is a king, the principle of caveat emptor prevails, that is buyer beware. So we see certain very important aspects leading to the definitions, the redressal forums in consumer justice delivery, and yes, unfair trade practices cases we will be doing. For example, the Indian Medical Association versus Shanta, where doctors also come under the scope of services. Then competition laws, yes, this is Professor Advocate HEMAS on consumer law and the Competition Commission of India. So first we see on the the examples of why this unfair trade practices followed in the business arena is troublesome. So number one is false or misleading advertising. Number two, misleading or deceptive conduct. Number three, imposition of unfair terms for acquiring goods or services. Number five, contracts in restraint of trade. In contract law, we had done void contracts, that is comprehensive restraint of trade. Infringement of intellectual property rights, patents, copyrights, and yes, trademarks. Of course, geographical indications too. Then state aid, that is importance of certain aspects like the election commissions and all that. Now, yes, unfair trade restrictive practices. The commonest example, the wayside vendor gives you the beautiful, the tasty popcorns for maybe 20-25 rupees. But if you go to the theater and you're going to have it with your friend over there, so it's going to be, the bill is going to be maybe 430, but can you show your eyes popped up? Yes, this can come under the unfair trade practices. So we see now the very important status of Indian competition law. Competition Act 2002 passed in January 2003. The Competition Commission of India established in October 2003 with one member, resigned in July 2008, the earliest competition law commission. It's very nice to see this. Full constitution of commission and enforcement could not be taken up due to the legal challenge leading to the process of amendments. The Competition Amendment Act 2007 was passed in October. Process for full constitution of the commission was set in motion. We see why are unfair trade practices bad. Yes, this has led to various amendments to the consumer protections. We see number one, frequent and widespread incidents of unfair trade practices in India due to number one, introduction of globalization, technological innovations, lack of consumer awareness. Yes, the unfair trade practices found in almost all the sectors, including pharma, that is pharmaceutical sector, education sector, food sector. We see the misleading advertisements, most common form of unfair trade practices across all sectors. That is, you see the cuts study. You can just refer some of the study material which I'll be giving you in the class. That's a cuts karke hai. You can just refer it. Unfair trade practices in market may have the following effect. Number one, impact on price and quality of goods and services. Impact on micro, small and medium enterprises. Impact on consumer confidence and trust. Now we see the salient features of the Competition Act. Yes, that's the latest justice delivery system in India pertaining to giving justice to the consumers who face unfair trade practices. Now we see the Competition Commission ka salient features. Prohibition of anti-competitive agreements, prohibition of abuse of dominance, regulation of combination, establishment of Competition Commission of India, and functions and powers of the Competition Commission of India. A very, very important topic for your exam. And this objective of Competition Act, that is to present that is anti-competitive practices, promote and yes, sustain competition, then protect the interest of the consumers and ensure the freedom of trade. Now we see, yes, this is in fact, how the regulation of competition takes place. That is to prevent anti-competition practices and also promote and sustain competition. Yes, Competition Act, India's pursuit of globalization, that is opening up of the world economy, has resulted in removal of control and liberalization of the economy. A key step in India's march towards facing competition, both from within the country and from international players, is the inception of a competition law in India. As a general rule, competition laws are premised upon the economic principle that competition is desirable in a free market economy. Competition laws seek to prevent businesses from engaging in practices that are harmful to competition and consumer welfare. This ideology is in some ways distinct from the ideology promulgated by erstwhile legislation dealing with the Restrictive Trade Practice, that is the Monopoly Restrictive Trade Practice Act. The Monopoly Restrictive Trade Practice Act primarily focused on curbing monopolies in the market. However, with the advent of competition laws in India, the focus has now shifted from curbing monopolies, there's a strict sense, to promoting competition. We see the Competition Act 2002 was enacted by the Parliament of India and governs the Indian competition law. It's a tool to implement and enforce competition policy and to prevent and punish anti-competitive business practices by the firms and, yes, unnecessary government interference in the market. Now we see the latest business laws, that is the competition law, are introduced to regulate the manner in which businesses are conducted in India so as to create a level playing field with effective competition in the market. The underlying intent for the statute is for the businesses to compete on merit and not with the aid of anti-competitive agreements or conduct. Now, having said that, however, it is very important to note that even though the competition laws can be used by businesses as a sword to ensure level playing field in the market, the intent of this relatively new statute in the Indian legal system is not to make it easier for the weaker businesses to survive in the market or require the more profitable business to give up their market share. Now, the importance of the Act. What does the Competition Act cover? A very, very important aspect of your syllabus. The Competition Act is not intended to prohibit competition in the market. Actually, what the Act primarily seeks to regulate are the practices that have an adverse effect on competition in the markets in India. Now, in addition, what happens is the Act intends to promote and sustain competition in the market, protect the consumer interest, and ensure freedom of trade in the markets in India. At the heart of the Act are various activities that will be prohibited as being anti-competitive. These activities comprises anti-competitive arrangement, abuse of dominant position, yes, mergers and acquisition that have an appreciable adverse effect on competition in India. Now, anti-competitive agreements. What are these? What are anti-competitive agreements? Are those that have as their object to or actually effect in preventing, in restricting or distorting competition in any market in India. Now, such arrangements cover not only arrangements but also decisions made by association of persons, enterprises, as well as the conduct of parties acting in collusion. The examples of anti-competitive arrangements prescribed under the Act are set out below. Number 1, directly or indirectly determining purchase or sale price. Limiting or controlling production, markets, technical development or investment. Arrangements for the sharing markets of sources of productions or sources of productions or provision of services. Directly or indirectly engaging in bid rigging or collusive bidding. Enforcing a condition on the purchaser of certain goods to also purchase some other goods. Entering into exclusive distribution or supply arrangements. Arrangements between persons involving a refusal to deal with a particular manufacturer or a customer. Yes, entering into arrangements to sell goods on the condition that the prices to be charged on the resale by the purchaser shall be the prices stipulated by the seller, unless it is clearly stated that prices lower than those prices may be charged, that is the resale price maintenance. These are the examples of anti-competitive arrangements. Very important to remember. It's easy. Purchase, that is indirectly determining purchase or sale price. Technical development, controlling production limit. Of course, sharing markets or sources of production or provision of services. Engaging in bid rigging or collusive bidding. Now, some of the aforesaid arrangements, that is price fixing, output limitation, market sharing and bid rigging, are outrightly prohibited, and as such any arrangement involving any of these activities shall be presumed to have an appreciable adverse effect on competition in India, while others are weighed against the impact on competition. Now, in recent case, the competition regulator has found 11 cement manufacturers guilty of cartelization and engaging in anti-competition prices. Now we see parallel and coordinated effects, behavior on prices, dispatching supplies in the market, and imposes a penalty of more than 6,000 rupees on those people who have defaulted on the law. Now affects its competitors or consumers or relevant market in its favor. Exactly what will constitute as contract amounting to an abuse of dominant position is not exactly defined, but we will be seeing case laws in the class. Abuse of dominant position means what? Yes, your syllabus may contain a case study and you need to analyze what is abuse of dominant position. The Act prohibits any conduct which amounts to the abuse of a dominant position, which may have as its object or effect an appreciable adverse effect on competition in any market in India. The Act defines the dominant position as a position of strength enjoyed by a particular enterprise in the relevant market in India, which enables it to, number 1, operate independently of competitive forces prevailing in the relevant market, or number 2, affects its competitors or consumers or the relevant market in its favor. Exactly what will constitute, as I said earlier, conduct amounting to an abuse has not been defined, but these are the criteria, and we will also see some case studies pertaining to this. Now, the general prohibition, however, the Act does prescribe certain forms of conduct as being likely to fall within this general prohibition. These are engaging a predatory pricing or any form of predatory behavior, predatory pricing or predatory behavior. Next is limiting production, markets or technical development to the prejudice of the consumer. Number 3, indulging in practices resulting in denial of market access. Yes, making the conclusion of contracts subject to acceptances by other parties, of course, of supplementary obligations which by nature or according to commercial usage have no connection with the subject of the contract, or leveraging the dominant position in another market to enter into or protect the relevant market. Now, it may be reiterated that merely being a large or a dominant player in a market does not amount to an anti-competitive behavior. What the Act seeks to target is a general prohibition, and yes, this should not happen because the very basis of the competition law is restraining the competition.